Hello, my name is Diane Miller. I'm an attorney with National Health Freedom Coalition. And today I would like to share with you our understanding of the constitutional rights to make our own healthcare decisions and all of the concerns that we have right now on the right to refuse the countermeasures for COVID. We have a PowerPoint presentation that I will share with you now, and you can contact our organization with any questions that you have later. So I'm going to share my screen and go through some of the basic concepts for the right to refuse and some of the issues that Americans are facing right now with their constitutional rights. So bear with me, I'll get this going here. There you go. So today, I would like to tell you a little bit about who we are and what our concerns are. The title of my PowerPoint is The Fundamental Constitutional Right to Make One's Own Healthcare Decisions. And at this time in the history of the world, it's November 3rd, 2020, it's a matter of survival. We have two organizations. One is a 501c3, National Health Freedom Coalition, and we educate citizens about their rights to make healthcare decisions. And our lobbying arm organization is called National Health Freedom Action. And we lobby and teach citizens how to pass laws, change laws, make the change happen that they would like to happen. Our basic premise is we have the freedom to live, to heal ourselves and heal each other, and to survive. It's our responsibility to survive first ourselves and our family, and then later in our community. My definition of health freedom is here. I'm sharing it with you. Health freedom is the internal and intentional steering mechanism within a person and within a community that guides us in life and death decisions. It is the freedom to make decisions for oneself and one's community about survival and health. It is rooted in the naturally occurring drive and commitment within people to keep themselves and their loved ones alive. Health freedom is a fundamental natural right of survival and personal sovereignty. Along with our understanding of health and freedom, because we are an organization that is promoting the power of law, and our attorneys here believe in the power of law, and we think that the power of law in America is the voice of freedom, we really look to the law. We look to change law if we don't like it. We look to what does the law say, and if our country is to survive, the basic premise of our country, what it would be founded on laws of the people. So questions are being asked to our organization and to many around the world right now. Will concentrations of power and money and the owners of technology dominate and replace our governments? Will the government of the people, by the people, and for the people perish from this earth? The American constitutional system needs to work to safeguard American liberties and health freedoms as governments and corporations grow and technology advances. This is our job now. If we want the vision of America to go into the future, we have to look at our constitutional foundation. When health freedom is in jeopardy, our lobbying organization, our action organization, NHFA, helps citizens pass laws to protect health freedom. We have an attorney staff, we do research, we draft laws, we do strategic conference calls, we do a lot of lobbying training to individual groups around the country. Sometimes we have traveled and made presentations, we've testified at hearings. And we send citizen alerts to lawmakers and authorities on behalf of citizens and give citizens ways to communicate with their legislators. So I first became involved in changing laws a number of years ago, maybe almost 30 years ago now, when I was representing a Minnesota farmer who was charged criminally for practice of medicine without a license. And I thought to myself, as a young attorney, why in the world would a farmer be charged criminally when he was giving colostrum from his dairy farm to ill people and they would get better? And former Congressman Berkeley Bedell had been helped and cured from Lyme disease by this farmer. And I thought, why would they want to put him in jail or charge him criminally? Well, when I went to look up what the law was for practice of medicine in Minnesota, the law said anyone who offers or undertakes to prevent or to diagnose, correct, or treat in any manner or by any means, methods, devices, or instrumentalities any disease, illness, pain, wound, fracture, infirmity, deformity, or defect of any person is practicing medicine. And I was shocked. I went, wow, that would mean grandmothers with chicken soup. That would mean, so we went forward. We got 2 hung juries because jurors did not want to put the farmer in jail. And after the third, we were going to go for a third trial and they withdrew all the charges. I just thought that law is not okay. Let's go change that law. So I got together with a number of people that were tracking that case, and they had already, in addition, had another practitioner that was charged. So we went to the Minnesota legislature and learned how to draft laws and lobby. So this is what we ended up with in Minnesota. It's much longer than this. It's 10 pages long. But some of the things that we protected now in Minnesota is the practice of acupressure, anthroposophy, aromatherapy, Ayurveda, cranial-sacral, and of course I put in colostrum therapy and healing touch, herbalism, homeopathy. And many of these practices are practiced around the state by wonderful practitioners, but they were all vulnerable to charges of practicing medicine without a license. Now there is a safe harbor for them to guide them that says they have to avoid certain prohibited acts, and they also have to give out a disclosure to their clients. So after the Minnesota bill passed, we got calls from all around the country wondering how we could help them. And not only for practice issues, but a lot of other issues. There are state health freedom groups working on many issues around our country. They're all doing wonderful work. And I encourage all of you to join at least one of them that is dealing with an issue that you're interested in. Here's some of the issues that we've been in touch with. Practitioner rights to practice, whether it's a medical holistic doctor or an unlicensed person. Vaccine exemption rights, so that parents have the right to choose, employees have the right to choose whether to have vaccines or not. GMO labeling, so that we know if we're going to choose a genetically modified food, that it's on the label, and we consciously do that instead of not knowing what we're eating. Right now, the best way is to choose organic food, which is not GMO. Electromagnetic frequencies, glyphosate Roundup, regenerative projects, Mercury and fluoride toxicity. And some of the work that groups do on these issues are so profound. For example, fluoride and mercury toxicity, they've made great strides to challenge governments from putting mercury and fluoride in either water or drugs or vaccines. And people need to understand how dangerous these toxins are to their health. This is an example of one of the pages on our website. It's the action alert page. So when we help a state group on a project that they're working on, we actually can make an action alert and we put it on our website and we send it out to our subscribers. And they can actually write to their legislator through our software so that the legislators get their communication. They can either take the letter that we write, or they can make up their own letter to send to the legislators. But now 2020 happened. So, wow, people are asking us, do we really have to stay at home? Is it right that I lost my job? Do I have to social distance and wear a mask? These are state governor emergency orders. They ask, what are emergency orders? Can governors do that to us and our families? How can governors do this without the legislature? So I want to explain a little bit about the background of governor orders for you to think about. I always like to think about state law as the police power to protect people's safety in their state. And then federal law is commerce or interstate things. That's kind of how I break it up in general. That's not always the case, but these are two categories of laws, state laws and federal laws. And our organization does most of our work with state laws and some of our work with federal laws. So for state laws, there's police power. So the Constitution institutes a state government, and it gives the state government authority. And they establish a legislature. And then the legislatures, they pass the state statutes. And then the administrative regulations are done by agencies from the executive branch. And then there are the special governor executive orders. Those are the four areas of laws that we pretty much focus on. We do have municipal and ordinance laws as well, but these are the four that we focus on. So for example, the Minnesota State Constitution says it was instituted for the security, benefit, and protection of the people, in whom all political power is inherent. And I'm really glad that that statement is in our Constitution, that it acknowledges political power is inherent in the people. So state lawmakers then go ahead and pass laws. But people don't realize that some of those laws are delegating to other authorities to do things, including laws that delegate authority to governors for emergency management. So the legislature actually delegated that power to the governor. So for example, in Minnesota, the governor has general direction and control of emergency management. This is just a quote from a law that's in place. May carry out the provision of the chapter during a national security emergency. And then also state statutes for emergency declarations are in law. And in Minnesota, a peacetime declaration of emergency, not a national threat of war, but a peacetime declaration of emergency may be declared only when an act of nature, a technological failure or malfunction, a terrorist incident, an industrial accident, a hazardous materials accident, or a civil disturbance endangers life and property, and local government resources are inadequate to handle the situation. This declaration of a peacetime emergency triggers the power of the governor to go ahead and make executive orders to deal with the emergency. So it's really important when they can declare an emergency. This is what the governor orders of Minnesota is based on now. To give you some background in how those emergency powers have changed over the years, 20 years ago, in 2002, right after 9/11, many states were asked to pass what at the time was called the Model State Emergency Health Powers Act. And these were very controversial acts because generally a governor had the authority in a natural disaster or a military situation, but it didn't have broad powers in health emergencies of any kind. And the Model State Emergency Health Powers Act didn't really define health emergency very narrowly. Some of the states put in bioterrorism, some of the states put in overall health emergency, so it could be the flu. So at the time, the ACLU stated that it was drafted as model legislation to increase state powers to respond to bioterrorism or other outbreaks of disease that the Center for Disease Control and others want the state to pass into law. Although such legislation is needed, the current draft of the Model Act unfortunately is written in a way that doesn't adequately protect citizens against the misuse of the tremendous powers that it would grant in an emergency. Now, many states went ahead and passed the Model State Emergency Powers Act, and you can find it in your own state statutes. However, I was at the Capitol because we were working on the other unlicensed practitioner issues, and we read that bill, and we were very upset because it would have put our doctors, it would have been a crime if a doctor did not do what the governor said in an emergency. And we were afraid of losing our doctor-patient relationship. And we were afraid that the governor could force us to get vaccinated and force us to do testing. And we read about the Nuremberg Code, and we were very adamant about changing our model state emergency bill before it passed. So we did add language, and we successfully, with much support from legislators, passed a section in the Minnesota statute. It's a right to refuse section. And we're pretty sure we haven't ever found another state that has this law in it. Notwithstanding laws, rules, and orders during a security emergency, a national security emergency, or a peacetime emergency, individuals have a fundamental right to refuse medical treatment, testing, physical or mental examination, vaccination, participation in experimental procedures and protocols, collection of specimens, and preventive treatment programs. So if you've been directed by the Commissioner of Health to submit to these, then you have to go through the rest of the statutes. And our statutes for quarantine really require you to be ill or be directly exposed, and the least restrictive means was added to our statutes on quarantine. So this is an important law for us Minnesotans. We are not aware that it has been challenged thus far. As I've been working with groups around the country, I've researched other laws often, and this year I researched the California emergency laws because of what is happening there. And this is a section of their code. Upon being informed by a health officer of any contagious, infectious, or communicable disease, the department may take measures as are necessary to ascertain the nature of the disease and prevent its spread. To that end, the department may, if it considers it proper, take possession or control of the body of any living person or the corpse of any deceased person. That is California law on the books today. So these broad governor powers have been in place since the Model Emergency Acts were passed 20 years ago. And I know that I heard right in March when this was all happening, one of the people on the news said, we got to take out those emergency powers and dust them off because this is the time we're going to use them. And I thought, wow, that's very interesting. So now they're being challenged for the first time so that our courts can actually evaluate, was that an overly broad delegation of power to the governor by state legislators? So state legislators have delegated power by passing the laws. So here's an example of the governor powers being challenged in Wisconsin of this year, May 13th, 2020. The Supreme Court of Wisconsin overturned its governor's stay-at-home order with judicial comments reflecting that expansive governor orders cannot go beyond the constitutional inalienable rights of citizens, even in the case of declared emergency. And I quote from the court, "It is especially in times of emergency that we must protect the rights of the people, lest we establish a dangerous precedent, overpowering less benevolent governmental officials in the future to oppress the people in the name of exigency." In September 2020 of this year, the governor powers were challenged in Pennsylvania. The federal court for the Western District of Pennsylvania declared unconstitutional the Pennsylvania executive orders of restrictions on gatherings and closing non-life sustaining businesses and directing Pennsylvanians to stay at home. Those orders were overturned as unconstitutional. They have been modified since then, but the original orders were overturned. The interesting thing about this Pennsylvania case is that it cited Jacobson v. Massachusetts, a 1905 case that has been often used to justify mandating vaccines. And oftentimes, when the vaccine mandates are challenged, they use Jacobson to say, no, government has the right to mandate vaccines. But in this Pennsylvania case, they used many of the things we've wanted to see the Supreme Court say, and that is how courts have evolved over time in the past 100 years since the Jacobson case to be more vigilant in the protection of civil liberties and the need to apply regular constitutional scrutiny when civil liberties are at stake. And as we know, over the last 120 years, we have really gotten more strict about protecting the liberties of vulnerable groups. Just recently, October 2nd, the governor powers were challenged in Michigan. And this time, this court actually overruled the constitutionality of the delegation of authority to the governor. So the court's conclusion was based on the fact that the laws purports to delegate to the executive branch the legislative power of state government, including its plenary police power, and to allow the exercise of such power indefinitely. So these are really direct challenges to whether a state legislature can delegate police power to a governor and not protect civil rights and liberties of people. So working with the California group, California Health Coalition Advocacy, they have now drafted legislation for right to refuse. And one of the main paragraphs of this that they want to focus on is how governments are using coercion to attempt to force people to do things. They won't do a mandate directly. They'll say, well, you have to get a vaccine if you want to work. You have to get a vaccine if you want to be educated. You have to get a vaccine if you want to use a daycare. So the coercion language that they have submitted is the government or its designees may not infringe upon or take away a person's ability to fully participate in necessary and important services and lifestyle choices and preferences, including but not limited to education, daycare, employment, travel, religious hobbies, entertainment, sports, and lifestyle preferences, based on a person's choosing to decline a countermeasure. And these countermeasures that they've listed in their statute draft are medical treatments or procedures, testing, physical or mental examination, vaccination, experimental procedures and protocols, collection of specimens, participation in tracking or tracing programs, the wearing of masks, the maintaining of measured distance from other humans and animals that is not otherwise unlawful, and the involuntary sharing of personal data or medical information. So they're working to set some parameters on the government for emergencies so that they can continue to enjoy and appreciate their liberties, their personal liberties. In addition to state law, the federal power of government has been extremely involved in the COVID 2020 issues, and I will not go into them in detail, but here are some of the ways that the federal government is participating on travel restrictions, interstate commerce, access to products, individual unemployment relief, individual financial relief, funds to state public health emergencies, and much, much more. So the intertwine between state and federal government is very deep right now. And of course, states may get funding if they do what the federal government wishes them to do. So there's a lot of play in this area of law. National Health Freedom Action focuses their lobbying work on curbing police power and protecting personal liberties. And National Health Freedom Coalition educates people, like I am today, about these issues. What you can do in your state or place. I recommend all Americans uphold the Constitution now. Really try and protect it, protect the foundation of our country. Find like-minded people taking action. Decide what you are willing to resist or what you're willing to do. Support legal court challenges and make sure you're working with other people together so you don't get exhausted or crashed out. Target the source of declared authority. Always understand how do they have an authority that infringes unnecessarily on your personal freedoms. Design a solution for the future. We are really interested in designing the future of the world. This evolution of technology and expansion will require us to design legal solutions if we want to keep a country of laws and introduce and pass laws and ordinances that really reflect your values and what you want the world to look like. Here are some photos of some of our leaders at different capitals. This is the Wisconsin leaders at the Capitol. We were there testifying in a hearing. Here's Massachusetts leaders. They even got a private tour from their legislators. And here's Safe Harbor, Maine at the Capitol when they passed their Safe Harbor bill for unlicensed homeopaths and herbalists in Maine. They put up their table and educational materials in the rotunda of the Capitol. So you wonder how to pass a bill in your state. Well, that's what we try and guide people to do. So NHFA attorneys help guide in conference calls, presentations, drafting, testimony. Oftentimes we will find a group maybe that has 3 to 5 people and they really want to do something. And I said, well, if you can do it for a length of time, every week meet together and our attorneys will come on the call and help guide you into how to pass a bill and review your language and kind of teach you about the process if that's helpful. I think many people don't realize who is representing you. And I just say, everybody, all people need to be representing our government. We need to be at the table long term if we plan to make a difference and protect health freedom. National Health Freedom Coalition, our educational organization, has founded the U.S. Health Freedom Congress. And the Congress has met 12 different times. It has voting members. And our goal was to bring different organizations that are working on health freedom nationally together so that they could meet each other and talk. They may be from national protection of vaccine exemption rights. They may be from practitioner rights. They may be from the FDA product protections, freedom of speech, GMOs, electromagnetic frequency and microwave radiation protection of citizens. And so this Health Freedom Congress has made resolutions, and all of their resolutions are on our website if you ever want to use them when you're doing advocacy work. Here's a picture of our last Health Freedom Congress in June of 2018. We didn't have one this year because of COVID, but there's been many great Health Freedom conferences virtually this year that we've participated in. So to wrap up this PowerPoint presentation and information session with you, I would like to share with you the principles of health freedom that our organization really believes will help when discerning what to do in different situations to protect people's health freedoms. There are 8 principles that the United States Health Freedom Congress has endorsed as well. Principle number 1 is the fundamental right of self-determination of individuals to be let alone to survive on their own terms and in their own manner. And I know that many of us have senior citizens in our family that really want to make their own choices and to be really respected in how they are treated towards the end of life. And if they want to be let alone, they should be able to be let alone. And people should not, even in younger generations, should not be telling people or forcing people to do something that they don't want to do with their own bodies. We have, as a sovereign entity, the right to exist on the earth in our own bodies and not have it not to be intruded upon by another person. So this sovereign right to be let alone is a very basic right for all of us to feel safe in our own bodies. Principle number 2 is the freedom to perceive and to act as one wishes to secure health and survival. So we think that we should be able to do what we need to survive. So if we need to go somewhere that we feel is safe, we do that. If we need to drink a supplement or an herb, we should be able to do that. So we have to act to secure our own health and survival. We have to have that freedom because it's different for all people around the world. What people do in every country is different when they feel sick. And they have a right to do what they can to secure their own health. Principle number 3 is the freedom to access who and what we need or prefer. And the reason that this is here is because it's a basic freedom that is often not protected. So for example, if you have a dominant culture and the dominant culture says that this is the way that you should be doing your health and survival, and then it outlaws 9 out of the 10 options, and it only leaves one option, that's the one it prefers, then that's really infringing on the freedom to access what you need. So what if you didn't have access to organic food? What if you didn't have access to supplement? Thank goodness we have the Dietary Supplement Act passed. What if you didn't have access to sunshine or clear air or water? So access to what you need to survive is extremely important and is very easily infringed upon by dominant cultures. Principle number 4 is the responsibility to do no harm. And of course, this is the founding premise of all medicine and healing. So if you have the opportunity to make a solution that does not harm someone, that that is the best thing to do when you're healing. And there's a lot of discussion about this because drugs in and of themselves are harmful. Therefore, the laws about them have the burden on the manufacturer to prove that they're safe before they come onto the market. But as you well know, there's a lot of chemotherapy and treatments that are extremely toxic, and there's a lot of political activity around cancer treatments because there are more gentle and effective measures that have been oppressed by dominant cultures. So the responsibility to do no harm is always in flux, and people are looking for options that can help them become healthy but don't pose the unnecessary risk of harm. Principle number 5, the responsibility to respectfully tolerate diverse options in health, healing, and survival choices. This one comes into play from people that contact our organization when they've gone to the doctor maybe and they are told that they have a treatment recommendation, and then they tell their doctor, well, I'd like to do some different things based on my background and my culture. And the doctor may discourage that. There's sometimes shaming going on. There's sometimes threat, like I won't be your doctor if you do something different. So this respectfully tolerating diverse options is really important. And I'm sure that many doctors are trained in what they know, and they don't know how it will interface with another diverse option. So doctors are really called to do much more research on the holistic practices that are being promoted now in the culture. Principle number 6 is the duty of corporations and institutions to be trustworthy, upholding health, freedom, rights, and liberties. You know, this is a very important one because corporations and oftentimes institutions have a duty to have profit. They have boards of directors. They need to look at bottom lines a lot. And their top priority might not be upholding health, freedom, rights, and liberties. So principle number 7 is especially for corporations. In light of the special legal nature of corporate entities and their systemic impact on the human family, we have 5 different things that we ask of corporations. Number 1 is honor and preserve the sovereign nature of individuals, the sovereignty of the United States, and avoid any negative impact on the sovereignty of other nation states. So preserving the sovereign nature of individuals is so important when you think about possibly even the very controversial subject of vaccines for this COVID. And if a person doesn't want to have a vaccine, the corporate incentives for moving this forward might be more strong than their incentive to protect the sovereign nature of individuals. The second one is honor and preserve American financial and cultural diversity and multicultural systems and avoid negative financial or cultural impacts on other nation states. So the way that money is moved around can impact diversity and multicultural systems, and dominance of financial and culture of one way and not another is really a problem because corporations have so much power because of their finance and their ability to promote a particular culture, that they really need to work hard at preserving cultural, multicultural diversity. The third one is avoid creating or being monopolies, avoiding the use of large monopolistic ownership of resources to dominate cultures, public policies, and regulations and laws. You know, I have one of our great leaders, Clinton Miller, used to say, monopoly when he was young, and that was 90 years ago, was a bad word in America. But then they made the game Monopoly, and it all of a sudden became a happy word. But he said it is one of the most dangerous things that can happen with our country, a monopoly to take over and really impact and create a dominant culture that isn't diverse, and then impacting public policies and regulations. For example, the current concerns about social media and big tech companies that are possible monopolies, and really how they are impacting public policy with their messaging and impacting regulations and laws. Number 4 is avoiding dominant control of natural resources, avoiding the suppression of access to natural resources, and avoiding potentially harmful modification or destruction of natural resources. So sometimes that bottom line for corporations doesn't really care about the natural resources of Mother Earth, and Mother Earth is feeling the impact of that. And I think that the dominant control of natural resources, it really needs to take into consideration that the earth is our sustenance in terms of our health, and that we need to stay in alignment with the source of nature in order to stay well. And the last corporate interest is one of the ones I think is most important. Avoiding promotion of products, policies, regulations that would encourage unlimited dependence on corporations and institutions, or that would discourage, prohibit, or otherwise negatively impact the ability or will of humans and local communities to survive and prosper without the corporation or institution. And this is so important. People are losing their ability to have health and survival because they depend on the corporate structure so much to have them be well. And that gives the corporations so much power over their lives. So avoiding promotion of products that would encourage unlimited dependence. And this, in my opinion, the advertising of pharmaceutical drugs is wrong. And so that's just a personal side note there. I hope that ends someday. So the principle number 8 is the duty of government to protect health freedom and to make no law or public policy abridging health freedom or its fundamental principles. The duty of government to protect health freedom is there. And now our question in this technological expansion in the world is, will technology and corporate technology take over governments? Will governments still have the power to even live out this duty that they have to protect health freedom? Is our Constitution strong? Will we be able to have our government still be able to protect our health freedom and to make laws and public policies that protect those freedoms? This is my hope. So in closing, I'd like to say, be an agent of change. Laws and customs must be carefully reviewed, revised, and even repealed if necessary, and new laws created to reflect the development, evolution, and spiritual maturation of a people. I think that freedom is an eternal conversation. True freedom requires us all to be constantly in conversation. Because if we have this foundational premise that we want laws instead of corporations or monarchs to regulate us, if we want laws to regulate, we have to be in constant conversation about what those laws are and what we want them to look like and how we want to evolve as we go forward. So I thank you for listening today. I hope that you can go to our website. We have National Health Freedom Action.org and nationalhealthfreedom.org. And if you'd like to send us your comments, we'd be happy to hear them. And thank you so much.